The Supreme Court on Friday ruled that a federal lawsuit by abortion providers challenging the constitutionality of Texas' new ban on abortions after roughly 6 weeks of pregnancy can proceed against some defendants even before the law is enforced against anyone. However, the Supreme Court allowed the Texas law to remain in effect during that challenge, which will proceed in a lower federal court. The ruling does not address whether a majority of the Supreme Court believes the ban is unconstitutional. Also Friday, the Supreme Court said that a second lawsuit seeking to void the same law, one filed by the Biden administration, should not have been granted a review by the justices. The law, which is unique in allowing private citizens to enforce it, has not been used against any abortion provider since it took effect in September. Abortion providers nonetheless sued to have the law ruled unconstitutional and barred from being deployed against them in the meantime. The rulings Friday came more than a week after the High Court heard oral arguments in a separate case, Dobbs v. Jackson Women's Health, in which the state of Mississippi asked the justices to overturn decades-old precedents supporting a constitutional right to abortion. Mississippi's new law bans abortions after 15 weeks of pregnancy except in medical emergencies or for severe fetal abnormality. The Texas Heartbeat Act has effectively put a stop to most abortions in that state by empowering private citizens to sue for at least $10,000 anyone who aids or abets an abortion after the detection of a fetal heartbeat, usually around 6 weeks or so into gestation. Women who obtain abortions cannot be sued. The Texas law, also known as SB 8, includes an exemption for medical emergencies, but none for pregnancies resulting from rape or incest. SB 8 explicitly excludes state officials from enforcing the law, which was designed to avoid having those officials named as defendants in challenges to the ban before it was ever used against a provider. The majority of justices said that for various reasons abortion providers cannot sue a state court clerk, a Texas judge, or Texas Attorney General Ken Paxton. However, they can proceed with the suit against other named defendants, who include executive directors of 3 state health boards, medical, nursing, and pharmacy, as well as against Allison Bentz, the executive commissioner of the Texas Health and Human Services Commission. That is because those boards and officials may take enforcement actions against abortion providers if the providers violate Texas Health and Safety Code, which includes SB 8. The Supreme Court ruling noted. The ruling noted that other viable avenues to contest the law's compliance with the federal constitution also may be possible, and the court does not prejudge the possibility. That comment came a day after a Texas state district court judge ruled that SB 8 violates the state constitution because of its mechanism authorizing private citizens to enforce the law. The state judge, in a ruling that was immediately appealed by an anti-abortion group, said that the law gave legal standing to people not injured by a pregnancy terminated and was an unlawful delegation of enforcement power to a private person. Justice Clarence Thomas, another conservative, in a dissent said that he would have ordered the plaintiffs' lawsuits to be dismissed entirely, arguing that they had no legal grounds to sue the government officials that the majority of justices allowed to remain as defendants. And Thomas wrote in a footnote, "As I have explained elsewhere, abortion providers lack standing to assert the putative constitutional rights of their potential clients.